Okay, I just started the vertical stream. I think that's it for now. That's all I need to do. Okay, so we're going to be doing the 80, 100, and 120 words per minute classes today. Oh, I forgot to say that I was going live on Pillow Fort. Let me do that real quick. Before I do anything else. Host. Okay, that should be it. I'm going to publish. Now I need to reblog it. There. Okay, now I'm done. Turn on the browser source. And the chat. Oh, I forgot to link. You know what? I'm always forgetting to do stuff. That's it. Okay, now I can do the 80 words per minute class. Okay. Let me make that audio.
Let's get started with some sentences. And these sentences are just to get your fingers moving, get you warmed up. And the words in these sentences are going to focus on final NCE and final NG. Ready? You were not in compliance. In essence, you have no defense. Vince will be sentenced today. The books do not balance. This is an act of negligence. His fingerprints will hang him. We lingered near the swings. I was wrong to go along. Does the ring belong to you?
Is that it? Okay. Compliance. Add a brief. Compliance.
All right, now for some number practice.
I want to do number practice.
Here we go.
Come on.
3,814. 4,316. 934. 9,427. 3,189. 7,002. 2,253. 2,793. 5,722. 728. 461. 325. 3,597. 4,355. 5,334. 5,953. 1,436. 5,799.
When I'm practicing by myself, I usually skip the numbers practice because it goes on for so long. Sometimes it's like 4 lines long of numbers. Oh, I hate that.
Next we have some sentences. And these sentences are focused on helping you build your vocabulary. And these sentences in particular are regarding weapons. You'll definitely hear about weapons in depositions, in court, so it's good to practice. All right, ready? Here we go. Guns are commonly used weapons. Rifles, pistols, and revolvers are names that refer to guns. Bullets, called projectiles, are fired through the barrel or cylinder of a gun. The diameter of a bullet is called the caliber. The study of the effects of firing a gun is called ballistics. Knives are also commonly used weapons. Knives may be described as single-edged and as double-edged. Jackknives are large pocket knives. A switchblade knife snaps open. All devices that cause death or injury are weapons.
Cylinder. Let me look that up. Cylinder.
This drill will focus on letters and numbers.
Letters and numbers. No.
Ready? C U U 7 8 2 3 H 6 5 4 7 G V F 6 7 5 G V T K W I 1 3 5 2 8 G 7 X 4 N 4 P 4 4 T 8 X 2 K P 4 4 8 2 B T 7 8 3 5 R F 8 R T Y 3 4 3.
So we have time for one more drill in this video.
And for our final drill, let's read from the wish list. Learn to rock climb, bicycle across the country, see the cacti bloom in the Mojave Desert, write a book that changes someone's life for the better, make the shot that wins the game just as the final buzzer sounds. That would be a thrill. That
That's it for that. Bicycle. Bicycle. It's not in my dictionary. How do I write bicycle? There, bicycle. Oh, I spelled it wrong? In the lookup? That's so embarrassing. I'm sorry. When you write in steno for so long, you start to lose English. Okay, so that's boik for bicycle. The brief is boik. Mojave. That's not in my dictionary either. Let me add it. Dictionary, words, not phrases or briefs. Oh, okay. There. Now to get to the next video. What video is this? For 10.
Welcome to literary and jury charge practice. Let's get started with some jury charge practice.
I like jury charge.
And the subject of this jury charge is Highway Traffic Act.
Highway Traffic Act.
Ready? It definitely appears that both motorists were driving at a speed lower than the maximum permitted under the Highway Traffic Act, but the fact that the speed of a vehicle is less than permitted by law does not relieve the driver from the responsibility of reducing speed when special hazards exist with respect to weather, visibility, or highway conditions. It was the duty of each of these drivers to keep his vehicle in his own lane of the pavement. This collision could not have happened if each had done his duty in that respect. It is for you, jurors, as judges of the facts, to determine where and how this accident happened and who was to blame. Whether both drivers were guilty of negligence, which substantially contributed to cause the accident, or if weather conditions alone were responsible. Should you find that both drivers were guilty of violation and the violation by each was a proximate cause of the accident, then neither party can avoid liability.
Judges of the facts. I've seen that. Yet it is a brief. There's a brief for it in this dictionary. I'm not sure I'm going to remember that. I can barely remember members of the jury.
All right, now this literary. Ready?
Literary time.
The same reporter wrote to me recently. Thanks for my buck up speech. Each time I needed that to focus. It really wasn't as bad as I tried to make it out each time. Now, what should I work toward? I can tell this court reporter likes having a full plate. One student wrote, I am writing cleaner. I feel a pass coming soon. I shouldn't be focusing on what everyone else is doing, right? It's all about me, right? The student passed her 2 certifying tests that week. Another student said, wow, you sure took the saddle off that elephant, and I now have to choose a better path. I replied, perhaps you do not want to swan dive into the mind games. Simply focus on your strengths and improve your weaknesses. I have not heard this expression. You sure took the saddle off that elephant. I'm not sure what that means. I think it's good. And then, I like that. Perhaps you do not want to swan dive into the mind games. All right, we'll have to get back to that one. Now let's try some jury charge. And the subject of this jury charge is contributory negligence. Contributory negligence.
Oh, that's criminal negligence. What is contributory again?
Ready?
Craig's.
Ladies and gentlemen of the jury, contributory negligence is a want of ordinary or reasonable care on the part of the person injured by the negligence of another, directly contributing to the injury as a proximate cause thereof. Contributory negligence may also be defined as a failure on the part of a person injured by the negligence of another to exercise ordinary or reasonable care to avoid the injury. One cannot recover damages for an injury to the commission of which he has directly contributed. If the passenger is at fault, whether because of doing something he should not have done, or in failing to do something he should have done, then he cannot recover any damages for injuries he has sustained. If the passenger's negligence has been a proximate cause of his injuries, he cannot recover from another who has also been negligent. So we have contributory negligence, proximate cause, ordinary or reasonable care, ordinary, commission,
I know that one.
approximate cause. All right,
Fraud.
some words to practice.
Approximate cause is fraud. What's passenger? I always get that one wrong.
Let's get back to some literary material. Ready? Here we go. New opportunities can begin with small steps. We can each evolve to a better place when we choose opportunities or when we are given ultimatums. Perhaps there has never been a better time to expand your skills. Or perhaps you believe there has to be a secret sauce to reaching your goal, your desired result. Yet you know that once you reach your goal, your tenacity will instantly focus on the creation of the next hurdle. We often use that word, and on to the next challenge. We are not individuals who rest on our laurels. Based on my many years of teaching and coaching, I can say that the normal state of a court reporter's or court reporting student's mind is setting goals and expanding his or her skills. Why am I writing about this now? I want you to know that you are not alone. Attorneys are requesting more and expecting more. Consumers and audiences want more too. The awareness for unprecedented access to an instant record from court reporters, captioners, and cart providers has changed our profession.
Profession is that's progression. That's hard to do. That hurts my hand. I prefer that.
All right, back to our Who Moved My
Not
Cheese?
The cheese book again. I don't want the cheese book.
Here we go.
Not the cheese book.
Now he felt that it was just a question of time before he found what he needed. In fact, he sensed he had already found what he was looking for. He smiled as he realized it is safer to search in the maze than remain in a cheeseless situation. Ha realized again, as he had once before, that what you are afraid of is never as bad as what you imagine. The fear you let build up in your mind is worse than the situation that actually exists. He'd been so afraid of never finding new cheese that he didn't even want to start looking. But since starting his journey, he had found enough cheese in the halls to keep him going. Now he looked forward to finding more. Just looking ahead was becoming exciting.
Have 4 more minutes in this video.
Let's get back to some jury charge practice. Back to the jury charge on contributory negligence. But back to the jury charge on contributory negligence. But before you can find that the plaintiff is barred from recovery because of his own contributory negligence, you must find that his negligence was a substantial factor which, together with the defendant's negligence, proximately caused the accident. If the plaintiff, in the exercise of ordinary care under the circumstances, should have been aware either that the defendant was unmindful of some danger known or apparent to the plaintiff, or that the defendant was not taking proper precaution in the operation of the car, and the plaintiff failed to admonish the driver or failed to take proper steps for his own safety. And if such failure to admonish the driver was a substantial factor in proximately causing the accident, then the plaintiff cannot recover, even though the driver was negligent. But if you find from the evidence that as the car in which plaintiff was riding approached the place of the accident, the plaintiff exercised the care that a person of ordinary prudence and care would have exercised under the same circumstances with regard to admonishing the driver, then the plaintiff was not guilty of contributory negligence.
One more minute. Sure what we're gonna.
Just a few words I wanted to mention. We had admonished, admonishing, admonishing.
That's not in my dictionary, but I can build it.
Ordinary prudence, substantial, approximately, and I think that will do it. Some words to practice, and that will conclude our literary end.
Okay, we're moving on to the Q&A.
Welcome to Q&A practice. Let's get started with some two voice. And we'll start with the defense.
Okay.
Ready? Mr. West, were you in a motor vehicle yourself when you first saw this car northbound? Yes, I was. The car that finally was involved in a collision? Yes. Was anyone with you in your car at that time? Yes. Who was that, Mr. West? 3 passengers other than my brother. All right. Who were these 3 passengers that were with you? One was Victor Patterson. Who were the other 2? Do you recall? The other 2 I didn't know. Pardon me? The other 2 I didn't know. They were friends of his. Of Victor's? Yes. Were you parked on Vermont? No, I wasn't. Were you parked on Maple? No. Where were you parked? About 25 yards from Vermont at a dead-end street. What direction does that run? The street that you were parked on. Southwest. Does it run more or less parallel with Maple? Well, it seems to run right through from one corner to another, but not directly. It runs right across the middle at maybe a 45-degree angle, I think. Do you know the name of the street? No, I don't. Does this street come to a dead end, more or less, at the northeast section of the intersection of Vermont and Maple? Approximately 35 yards.
I did terribly on that. Okay, let's just ignore that. How bad I did. I got confused and I thought that the plaintiff was talking. The plaintiff lawyer was talking, but it wasn't. Defense attorney. Whoop.
All right, now that we're warmed up, let's do some for voice practice.
For voice is so difficult. Okay. I'm ready.
And we'll start with the plaintiff.
Okay.
Ready? Put a P by the second arrow there. The other reason it was used like that is a lot of people drove up in here. I don't know why they went up in there to ride motorcycles or dump trash or whatever. That's the only access to this property at this time. There was no other access to this property at all except going back through this area. Is it fair to say that the most common use of your vehicles, as you've indicated, is to the B location? We never went as far as that. The arrow you've drawn, which you put a B by, we used that more often than we did that area, and A was used very seldom. Yes. I don't have anything further. Do you have anything? Yes, thank you. I have just a few questions. I appreciate the opportunity to clarify a few things. You mentioned that 2 to 3 years ago, somebody had placed a lot of dirt on the west end of the easement property. Is that correct? It wouldn't be the west end. Oh, the easement? Yes. It would be the south side of the easement. The south side at the west or all along? All along the whole south side of the easement. Excuse me. It would be the east side of the easement on the south side of the easement. The southeast side of the easement is where all of the dirt was placed. Are you saying there wasn't any dirt placed anywhere on the west end of the easement? No. Yes, you are saying that. I'm saying that. Do you know who put the dirt on what you're calling the south side? The Elliots did. The Elliots put that there. It's the southeast side. What you're saying is the abandoned railroad property? Yes, I think that's what we're calling the easement property. It's all in this area right up in here. I don't know if you want me to draw on it or not. He hasn't asked you to yet. If he asks you to, then do it. I don't want to clutter it up. It's all this area up here. No dirt was put back in here at all. Do you see the line that's on the easement property that runs along in a curve? That line, when you just showed me where the dirt was, you went considerably south of that. This whole area right here. Let's note that Mr. Miller is pointing principally to an area that's south of the easement. Is that correct? Excuse me, there's some dirt that goes on the easement itself. I'd say it's about half the easement, maybe a little more. Half has dirt on it, this whole area up here. And the dirt also was put south of the easement. Is that correct? Yes, it was. All the way down to the liquor store on the corner. The dirt was put all of the way into this whole area right here. Is that the same area where the fence was erected? That's correct. The fence was erected there. If I understand correctly, you said you have a pretty good idea of what was happening in respect to the easement property since 1972. That's correct.
Is that it? Yeah, that's it. Okay. Principally. Principally. I was trying to spell it with a B? Why? Why was I doing that? What else? Anywhere? Okay, it has to have an asterisk there. That's why I messed up. I didn't put the asterisk there. Drive. I think I'll lower the volume for the audio. I feel like it's too loud. Okay. Next, we're doing the test.
This will be an 80 Q&A practice test. Plaintiff attorney Mr. Santos, capital S-A-N-T-O-S. Defense attorney Ms. MS period Reyes, capital R-E-Y-E-S. All right, and we'll start with the defense.
Starting with the defense.
Ready? The one that was involved in the accident. Yes, I know. Okay. Have you given any other written statements to anyone else? No. About this accident? No. Have you given any recorded video or audio statements to anyone else about this accident? No. Okay. I think that's all I have. I just have a couple follow-ups real quick. Sure. With regard to the interview that you gave with Mr. Milton, you mentioned you don't know who he represented. I did not. Okay. If he would have been hired by any of the parties in this case, you would have given the same statement. Is that fair and accurate? Yes. In other words, what you did is you just told the truth. I just told the way I remembered it. Okay. Now with regard to the you gave some testimony, and I think you also mentioned in your statement that what you tried to do is to move your vehicle a little bit to the right, yes, to get thinking if these motorcycles want to pass, they can go ahead and pass. You wanted to give them a little bit of room, right? And you're not exactly sure how far to the right you moved. No, but you just know you moved a little to the right. Yes, and it was your impression that the motorcyclist who ultimately came in contact with the van Was it your impression that he was actually in the eastbound lane at some time? Yes. Asked and answered. The motorcyclist that was involved in the accident, and I want to make sure I'm clear on this. He was not the motorcyclist that you saw pass you. Is that right? That was a poor question, vague and ambiguous. The motorcyclist you had seen when you're farther back on Main, further east as you're westbound, some motorcyclists passed you, you mentioned, right? Yes. The 40 to 60? Yeah, the 40 to 60. All right. Okay. They had passed you, and at the time they had passed you, obviously the one who was involved in the accident was still behind you. Correct. And I just want to make certain that I understand. The guy who was involved in the accident, yes, he had not passed you. He had not passed you before the accident, you mean, and come back? Right. No.
Oh, okay. Well, I didn't do too bad on that one. I did miss sentences, entire sentences, like over here. Because I'm still, it's still a struggle trying to switch between attorneys. I still have trouble with that.
My tip for today is one that I often have to check myself on, and that is regarding using commas in an address. And the rule is basically, in an address, you're going to use a comma for everything after the street name. So let me give you an example. I used the 877 Inman Avenue, comma, Edison, comma, New Jersey, comma.
I'll just skip this. YouTube switched up the video player layout. It looks so different now. I wonder why they did that.
Drill class. We're going.
Oh, this is really low. She's talking really low. Hide that real quick. The volume. Cities and states.
Washington, D.C., Phoenix, Arizona, Denver, Colorado, Cleveland, Ohio, Hoboken, New Jersey, Fort Wayne, Indiana, Pierre, South Dakota, Billings, Montana, Seattle, Washington, Madison, Wisconsin, Cleveland, Ohio, Lincoln, Nebraska, Detroit, Michigan, San Antonio, Texas, Orlando, Florida, Gallup, New Mexico, Albany, New York, Atlanta, Georgia, Springfield, Illinois. Moving right into a brief
God.
review. These are sentences using these following briefs that you learned in theory: January, February, minute, general, yesterday, opinion. Here we go. January begins the new year. In just a minute, the curtain will go up. Yesterday was February 17. Go ahead and express your opinion. There seems to be a general malaise. The inauguration is January 20th. What is the general policy? I will tell you my opinion in a minute. What did you do yesterday? Valentine's Day is February 14. I only have a minute. Liam is informed in a general way. You must value the opinions of others. January is generally quite cold. Lincoln's birthday is February 12. The opinions expressed are not necessarily those of the staff. The pipes were ordered yesterday. Generally, it only takes a minute to get your order. Yesterday was the last day of January. We will need to use every minute. Do you agree with his opinion? His general condition was good when I saw him yesterday. Do classes start in February or January? That may be your opinion, but it is not my opinion. Yesterday was extremely hot for a day in January. February has 28 days. Can you take a minute to look at the plan? He shares most of our opinions. If you take a minute to look at it, generally you will not make a mistake. Are you going to spend January and February in Florida? I will let you know the minute that I hear from General Nelson. I called him yesterday. January has 31 days. It took several minutes to get an answer. I think it was generally understood at the meeting yesterday. It was not the consensus.
Okay, we're going into an ad break, so I'll be right back. Okay, we're back.
All right. I'm going to give you a couple of legal briefs along with sentences.
Okay.
Today you're going to learn assault and battery, SAUB, and beyond a reasonable doubt is Y final RD. Now, some people like to write that as YARD, beyond a reasonable doubt, and that just means if you do that, you have to flag yard so you don't have a conflict. Okay, here we go. Here are your sentences. Assault and battery, SAUB. The charge was assault and battery. She must prove assault and battery. There was no evidence of assault and battery. She said it was a case of assault and battery. Now we're moving on to beyond a reasonable doubt, either YRD or YARD. You must agree on this point beyond a reasonable doubt. Beyond a reasonable doubt, they proved their charges. The attorney proved his case beyond a reasonable doubt. The plaintiff must prove his case beyond a reasonable doubt. Okay, now I'm going to give you a few briefs from the 100 brief sheet, and then I will just go through and review a few times so you get used to hearing it and writing it. Okay, crosswalk, KRAUK, crock. District attorney, DAE. Driveway, DROI, droy. Eastbound, EB. Easterly, ERL. Eastern, ERN. Estimate, STIMT. Okay, so we're going to stop there and I'm going to go through those again. Okay, here we go. Ready? Crosswalk, district attorney, driveway, eastbound, easterly, eastern, estimate. Crosswalk, district attorney, driveway, eastbound, easterly, eastern, estimate. District attorney, crosswalk, eastbound, estimate. Driveway, eastern, easterly, driveway, crosswalk, eastbound, easterly, eastern, estimate. Okay, moving right into some medical triplets.
Medical.
I'm going to read these at a slower pace. And again, if you don't know what it is, you're just writing it phonetically. Okay.
Ernie.
Here we go. Alkaline phosphatase level. Magnetic resonance imaging. Interrupted silk sutures. Horizontal mattress sutures. Ruptured invertebral disc. Endometrial biopsy curette. Superficial femoral arteries. Systolic ejection murmur. Cervical cesarean section. Lateral subtrochanteric incision.
I don't even know what she.
Acute inflammatory abscess. Total cardiopulmonary bypass. General inhalation anesthesia. Chronic coronary insufficiency, computerized axial tomography. We'll stop
Did
there.
she say tomography?
Again, you're just writing those phonetically.
Tomography, but I'm spelling it wrong.
If that were a test and you're not sure what it is, you look it up in the medical dictionary. Okay. All right. So I'm going to give you some words that end with Y. So we either write that with an AE or some people like to use the long E. Okay, here we go. Alley, sorry, daddy, ugly, nearly, sadly, story, party, penny, Peggy, caddy, Billy, kitty, shady, fussy, muddy, dizzy, nutty, purely, navy, sunny, likely, gladly, friendly, hearty, lady, hardly, badly, body, hurry. Here are your sentences. Ask Daddy if you can have that pretty fuzzy kitty to take home. He rode the pony around and around until he got dizzy and nearly fell. Peggy was very fussy about putting the plants in a sunny place. Her fairy godmother sadly turned her pretty dress back into rags. When it is warm and cozy, tell the story about the bright new penny. The lady was trying to calm the fussy baby by rocking her. I could gladly shoot him for all the nutty things he did at the party. If you go now, you are likely to get home before the road gets muddy. It would be friendly to carry the load for me. And hopefully you phrased if you go, F-U-G. All right, so that concludes
Wow, that went by really fast. I'm surprised. Okay, we're in class 30. Video, I go to next.
Hello everyone, welcome to the literary and jury charge portion of the 100 class. We're going to start off with some legal opinion. Okay, ready? At the time of this decision, there was a statute which provided that no appeal shall be obtained from the decree, but the same shall be final and conclusive. This statutory provision was said by the court to be nothing more than a recognition of the principle of public policy just previously mentioned. That provision of the statutes no longer remains a part of the statutory law of the state, but since its elimination, the Supreme Court, in the case of Mulligan versus Mulligan, has affirmed the doctrines announced in the case of Parrish versus Parrish, the Supreme Court reversing the decision of the Circuit Court of the 3rd District found in CCNS 585. It is clear that the Supreme Court has steadily adhered to the general principle announced in Parish versus Parish. An examination of the record in the case at bar discloses facts which present an entirely different problem for solution. In the parish case, the action was directed to the annulling of a decree that had theretofore been granted divorcing the parties to the action. In the case at bar, the evidence shows that by the action of the Common Pleas Court of Montgomery County, Pennsylvania, a court of general jurisdiction which had jurisdiction of the subject matter and of the parties, a decree had been rendered in favor of the plaintiff in that case and against the defendant. The defendant in that case, plaintiff, in our common pleas, had filed an answer in which she denied the charges of adultery made against her by the complainant in that action. The exemplified record of the proceeds or proceedings in the Pennsylvania case shows that upon the evidence adduced at the trial, the court found her guilty as charged and accordingly granted a divorce to the husband. The effect of this decree was to fix positively the legal status of the parties so far as their matrimonial relations are concerned. This status having been fixed by a severing of the matrimonial relation, public policy forbids any court to interfere with the status thus fixed.
That was difficult.
Okay.
It was like 4 straight minutes of
I have
writing.
a narrative answer. I'm going to read it once at 80 and then again at 100. Okay? Here we go. Ready? I am basing most of my arson report on the remaining material. The roof was completely burned in this area. The rafters of the ceiling remained, and I used the burn patterns in finding the point of origin. The heaviest burn patterns will be close to the area where the fire started. Then the burn pattern will diminish as it goes out from there. By the time I got there, the ceiling had a hole cut in it where the fire department had gone in and removed part of the roof. Okay, now I'm going to read that same narrative answer but at 100. Here we go. I am basing most of my arson report on the remaining material. The roof was completely burned in this area. The rafters of the ceiling remained, and I used the burn patterns in finding the point of origin. The heaviest burn patterns will be close to the area where the fire started. Then the burn pattern will diminish as it goes out from there. By the time I got there, the ceiling had a hole cut in it where the fire department had gone in and removed part of the roof.
I messed up fire department that time.
Okay, I have an article here called Loving Memory. Here we go. Ready? The sanctuary was...
Okay, first of all, how do I write sanctuary? Sanctuary.
Started. The sanctuary was started in 1995 by Carol Buckley and Scott Blaze. The two former elephant trainers had seen enough abuse and neglect at circuses and zoos to inspire them to create a haven where elephants could live out their lives. The sanctuary would offer what Buckley considers the three staples for a happy elephant: freedom from dominance, room to roam, and lots of other elephants. At the 2,700-acre preserve, the 19 African and Asian elephants in residence are allowed to exist as they would in the wild. Elephants in zoos and circuses are typically moved with a tool called an ankus, a nasty-looking wooden shaft with a metal hook protruding from the top. It's banned at the sanctuary. Instead, we created a system where dominance does not exist at all, says Buckley. We give them the option to say no. Buckley confirms, just as we've read in National Geographic and seen on the Discovery Channel, elephants show great compassion toward one another because the elephants she works with have suffered neglect and abuse.
I need to fix that. With changes it. Like, I don't like.
Buckley sees this empathy demonstrated in some unforgettable scenes, including this remarkable story. A circus refugee, Jenny had often been tied up for 23 hours a day or crammed into small train cars traveling from one city to the next. After suffering a crippling leg injury, she was dumped at a dog and cat shelter.
A whole elephant?
Which was ill-equipped to care for an elephant, let alone an ailing one. An animal rights activist contacted Buckley, who brought Jenny to their sanctuary in Hohenwald, Tennessee. Freedom's a wonderful thing, and Jenny was eager to experience it. She was kept alone in a yard for one day due to injury, but that proved stressful to her. So she was let out with the rest of the herd, and that's when she stumbled on a friend from the past. Jenny was still a calf when she and Shirley first met years before, toiling together at a circus. Although they'd spent only a few weeks with each other, Shirley assumed the role of surrogate mother to Jenny before they were separated. But that was 23 years earlier. Would they remember? Jenny knew right away who Shirley was. Soon, Hohenwald was rocking as the two greeted each other with trumpeting and celebratory bumping. Shirley and Jenny instantly fell into their old routine, wandering the sanctuary side by side. Very cute.
Woo!
All right, so we've got some opening statements here. Here we go. Ready?
Back.
You are going to hear that the crime lab came to process this scene, that arson investigators came to process the scene. They recovered at least on that first day, that is, Tuesday the 8th, as many of the bones that they could recover from this obvious destructive area, this burn area, and the evidence will show how the bones were recovered and transported for identification and examination. You are going to hear that the officers, remember, this is on a Tuesday. They had already gotten there on the previous Saturday. The officers weren't able to recover or even examine this area. None of the police officers themselves, humans, or with the assistance of canines, cadaver dogs, or bloodhounds, or any kind of search dogs, were not able to inspect this particular area because of a German Shepherd that was vicious, which was guarding that particular area or that particular burn area. This is a photo that just assists you and explains why it took until Tuesday to find these human remains in that area. All right? We will move a little bit more quickly into the following, or into the balance of that week. The recovery of those bones, you will hear, were very, very small in size. They were also very degraded. They were charred, but they were all examined by a forensic anthropologist. We will talk about that a little bit later in the case. But what you need to know on Wednesday is that they were able to say that they are human bones and that they are from an adult female. The officers, obviously, at this point, believe that this is the site of the mutilation and the disposal of Rachel Ramsey. Later on the next day, on Thursday, this burn area, this is a little computer generated image of the burn area where the officers were able to further excavate and recover all the rest of the bones that were found in that area. And let me just take a moment to tell you about these computer generated images that you are going to see. There is a gentleman by the name of Ray Austin. He is an employee with the Indiana State Patrol. Ray Austin was at the scene for at least 7 of the days that led up to or included the processing of the scene. And Mr. Austin, you are going to hear evidence that he took at least 4,100 measurements and later created not only still images of the exterior of the property, but also exterior of Mr. Mack's garage, trailer, the burn area, the Jackie and Martin areas, but also some of the interiors as well, because you are not going to be able to go out there, because you are not going to be able to do a scene visit. Mr. Austin created for you kind of a tour. Many of you might be familiar with at least some kinds of computers, virtual tours that you're able to kind of tour the area and get kind of a description of the land, if you will, and you will hear how accurate the depictions are. You are going to see it. You are going to see the virtual tour so that you get a better flavor or feel for where one item might be in relation to another. All right? We also have for you these computer generated images that you will see. Okay, we're going to stop there, but we have more, and I'll finish that in our next.
Wow! That was a lot. Processing. Bras. Exterior. I had trouble with that one. Exterior. Exterior. Okay. Let's go to the Q&A now.
Hello, welcome to the 100 Q&A practice. We're going to start off with some dictation, and defense will be questioning. Ready? You are going to hear the brief subpoena, which is initial S, final P. Here we go. Who keeps the records of income and expenses for the creative company? Me. In what book or record do you keep records of income and expenses of the creative company? On a piece of paper. On one piece of paper? Oh no. What do you call whatever record you keep of the income and expenses of the creative company? Income and expenses, I guess. I'm not sure. Is that what you call it? Well, I guess the income and expenses record. Do you have a journal or book or some kind of set of papers in which you keep these income and expense records? You have subpoenaed them all from my accountant. He will not deal with me anymore. You have them all. Please answer the question. I can't and won't do that. Okay, moving into our next set of Q&A. This is going to be plaintiff questioning. You're going to hear approximately, which is initial P, final L. Police, P-L-I-S, that's like a squeeze. You're going to hear, let's see, estimate, S-T-I-M-T. Is that correct? Is S-T-H-A, final R-K. Vehicle, V long E-K, veek. And those are just some of the briefs, main briefs that you'll hear in this, okay? Here we go. When you stopped this vehicle, did the police unit stop in back of it or alongside of it or in front of it, or how? In back of it. Did you and Mr. Morris both leave the police vehicle? Yes, sir, we did. Did you have your guns drawn? Yes, sir, I did. Did Mr. Morris go to one side and you go to the other side of the pickup truck? No, sir. Did you order Mr. Warren out of the truck? Yes, sir. Now, when Mr. Warren was ordered out of the truck, tell us how he got out of his truck. Well, he got out of his vehicle with his hands in front of him. With his hands extended. They were extended upward at about a 45-degree angle. I would estimate. Palms downward? Yes, sir. Approximately what period of time elapsed from the time of the call until the arrival of the backup unit? The backup unit arrived, I would say, approximately 2 minutes after we stopped Mr. Warren in his vehicle. And that backup unit, the function of the officers in the unit would be to take care of the vehicle. Is that correct? Yes, sir, and render any assistance that we might need. What time of night was this approximately? It would have been approximately 11:50. Are you sure it was 11:50? Well, I looked at my watch. Okay, Switching back
Oh
to
my
another
god, it's been
transcript.
5 minutes. What do you mean we're switching into another
We're going
transcript?
to hear at the time, which is TET, headlight, initial H, final LT. Alcoholic is KHOL, and then come back for IK, alcoholic, because alcohol is just KHOL. Again, approximately, initial P, final L. And then children,
Chill.
KHIRN.
Here.
Okay, here we go. Ready? Now calling your attention to the date of October 18. You were driving a car that was involved in an automobile accident. Is that correct? Yes, sir. At approximately what time of day or night did the accident happen? I think it was about 7 p.m. or thereabouts. All right, was it dark? I think it was, sir. Were your headlights on? I think they were. I don't recall. Were the headlights on the other car that struck you? That I wouldn't know, sir. All right. Now, was the weather clear and dry? Yes. The streets were dry, weren't they? Yes, they were. Now, at the time of this accident, where were you going? I was going down Valley. That's toward Beach Boulevard. But I don't know whether it is south, east, or west. He meant what was going to be your destination. Where were you going? I was going home. I lived on 5th Avenue. You were going home? Yes, I was. And where were you coming from? Where was I coming from? Yes. Did you come from a movie, a store, or what? I was coming from a friend's house. And what friend was this? What was his name? Jim Carter. Carter. Was he in the car with you at the time of the accident? Yes, he was, sir. And for what reason had you been to his house? I was just visiting over at his house. But why was he coming back with you? I was going to drive him to work. On the night of the accident? Yes, sir. And where was he working at that time? I believe he was working in Long Beach. And you were going to drop your family off at home before you went to take him down to work in Long Beach? That's right. Had you had anything of an alcoholic nature to drink at his house? I don't drink, sir. Well, had you had anything to drink that day of an alcoholic nature? No, sir. Do you remember what day of the week this accident occurred on? It was a Sunday, sir. And what time had you gotten over to his house, approximately? Oh, I don't know. It was in the afternoon sometime. And was your wife with you? No, sir. Where was your wife at the time of the accident? She was working at the time. Where was she working? Huntington Hospital in Pasadena. What time was she getting off work? She was getting off early that night. That is why I was to go home. Were you going to go pick her up? No, she was supposed to go home by herself. Did she have her own car? No, but she had a ride. Do you know what time she was supposed to get home approximately? No, but I was to go home first anyway. I was supposed to meet her over to this Mr. Carter's house. Yes, it is kind of confusing. All right, well, at some time in the afternoon, you had gotten over to this Mr. Carter's house, right? That's right, sir. Did you have all 4 children with you? Yes, sir. And did he have any children? He has 2. And you had just visited with him that afternoon. Is that right? Yes, sir. That's right.
Oh, that's it. My back. Damn. I will never get used to punching over my machine. I try and raise it up, but it doesn't seem to be... Okay, I raised it up a bunch now. Hopefully that'll help. Next, we'll do the test.
Hello, everyone. Welcome to the...
Okay, she's loud now. Let me, fix this.
$100 Q&A test. Plaintiff attorney is Mr. Cordova, Cordova. Defense is Mr. Copeny, Kopeny. Again, plaintiff attorney Mr. Cordova, Cordova. Defense is Mr. Copeny, Kopeny. And this test is going to start with defense attorney. Ready? Did he tell you when he picked up the tab? I believe I talked to Officer Moore also. I think we might have went over the times, yes. Was Officer Moore present when you talked to Mr. Kern? I don't believe so. Now, did Mr. Kern tell you that he had delivered a white female to the same address with Mr. Moon? Yes, sir. At the same time that morning? Yes, sir. Did you show him the pictures of white females? No, sir. Did you ask for a description of the white female? Yes, sir. I believe he had given that description to Officer Moore. I am not sure if I asked it again or not. Did Mr. Kern tell you that this white female had helped carry the radio equipment into the house? I am not sure if she helped carry it in or not, sir. I'm not sure. Did Mr. Kern tell you? I am not sure if he told me that she helped carry it in. Did he tell you he himself had helped carry it in? To my recollection, yes, he did. So your testimony is that you can't remember whether or not he told you that the girl helped carry it in? Asked and answered. Go ahead, you don't remember? I don't remember if he said the female helped carry the property in. At the front door, when Mr. Moon opened the front door, you testified, you suggested that he get dressed. Will you tell us what exact words you used? Again, this is, I can't recall the exact words. Probably something like, why don't you get some clothes on? And what did Mr. Moon do then? As I recall, he did not say anything. He just turned around and walked back into the apartment. And was that after you advised him that he was under arrest? Yes, sir. Did you follow him immediately? Yes, sir. And where did he go then? He went to the foot of the bed. Did you enter the apartment after telling him to get dressed? No, sir. So you placed him under arrest from outside the door. He was standing inside the door? That is correct, sir. Officer, you testified you had a police report written by Officer Moore with you at the time that you entered this apartment. Had you discussed the contents of that report with Officer Moore? Yes, sir. When? When I arrived at the police station. Would that have been that morning? That morning, approximately 7:30. Officer, will you tell us how Mr. Kern described the property, the radio equipment that he had loaded into his cab? He described it as a Sony, I am quite sure. You have already testified to the items that are in your report. Do you remember in any more detail any descriptions that Mr. Kern gave you? No, sir. Did you observe radio equipment? Strike that. Would you describe the items you observed inside the apartment? It was the same property, same items as listed on the front of the original report as being stolen.
Oof. That was tough. I had my suggestions thing behind Notepad++. So I'm sorry to myself. Didn't mean to do it.
Hello there, this is your 100 tip for the day. In our Q&A practice, there was a witness that gave testimony. He said something about someone using a 30-06. So, referring to a particular gun. And you would write that on your machine as 30, come back for either AUGT, like it sounds, or you can write it as OUGT, like it's spelled, and then come back for 6. Okay, so the way you would transcribe that is 30.06. So that ought, where you have ought, that's where you would replace that with the actual point, like the decimal point. So that is what 30.06 means.
Okay. Let's try the 120 words per minute drill.
Hello, welcome to the drill portion of the 120 class. We're going to start out with a basic word drill, And even though these words are basic, I want you to focus on your accuracy. Okay, this is about accuracy and not so much about speed. Okay, ready? We're going to start out with the words. That, vet, quit, quell, quip, zip, zap, quart, quill, squirt, squid, squat, belt, felt, raft, wept, slept, dirt, part, port, strut, strip, stilt, thrill, throb, shrill, sprig, squad, twig, plot, plus, skit, skid, verb. Now here are some phrases that follow the same pattern with a lot of the words are initial V along with initial V final T and final RT words as well. Ready? Zip it up. Stop the vet. Zig or zag. Pop the quiz. Have the quiz. A full quart. Many quarts. Fill the vat. Lug the vat. Tip the vet. The vet quipped. Quit it. Short quiz. Short verse. Okay, now here are your sentences. The quilt is red. Dad is quitting. Is the quiz hard? The pigs are fat. The vets have left. The car zigzagged. The vet fed the mutt. I will quit if it hurts. Are the verses short? Will her dad sell the car? Have the cats purred? Sis zipped up her skirt. The cell will be mopped. Have the squad cars left? The cells are full of thugs. Is the vet with the dogs? Okay, I have a license plate drill for you. This also includes descriptions of automobiles along with the license plate number. Okay, and you can also phrase license number. I do I write that as L-I-N, Lynn, and then if of course the proper name Lynn comes up, I flag it because it's a proper name that's one syllable. Okay, but just if you hear license number, that's what I use for that phrase. Okay, here we go. Ready? 2001 GMC Sierra Black, license number IF13761. 2009 red GMC Yukon Denali, license number TF23717. 2000 silver Pontiac Sunfire, license number IMTC 431. 2004 blue Pontiac Grand Am, license number 2TMC 401. 1997 Hunter Green GMC Yukon, license number 7F43510. 1999 white Jeep Wrangler, license number 4BT U473. 2008 gray Toyota 4Runner, license number LF13749.
I did not. I could not do that one. Add starts in 1 minute, though. And I'll be able to take a break.
I have some Latin and French
Latin,
words
French.
for you.
I gotta add these.
Yeah, I'm going to give you the word and then the sentences. We've got carte blanche.
Carte blanche.
Quantum meruit. Ultra vires. Quantum meruit.
I need to look these up. Meruit. I'll be right back. Okay, we're back. Quantum Meruit. Yeah, I need to add this to my dictionary. Meruit. I'm just gonna have the video not play so that I can get down these words. Ultravirus. Right there. It is in fact pronounced that. Ultravirus. Intravirus. Okay.
Okay, I'm going to read you your sentences. Carte blanche means unlimited authority. Generally, carte blanche gives another person the power to fill in a blank instrument as he chooses. Quantum meruit literally translates to mean as much as one deserves. Using the theory of quantum meruit, one may recover a reasonable value for any work or service performed. An act or contract which is not within the powers of a corporation is an ultra vires act. Ultra vires acts are generally outside the scope of authority conferred by law. The opposite of ultra vires is intra vires. A matter that is intra vires is considered within legal powers, control, or authority of an individual or an institution. I have some medical words.
I don't write
and
institution. Definition.
Definitions. Ready? Carotids, the principal arteries of the neck. Cerebral, of or pertaining to the brain. Cerebrospinal fluid, fluid of the brain and spinal cord. Cervical vertebra, the upper 7 bones of the spinal column. Coagulate, to clot. Coccyx, the last bone of the spinal column. Cole's fracture, otherwise known as Colles. I've heard it both ways. Okay, so Colles and Colles fracture. Transverse fracture of the lower extremity of the radius with displacement of the hand backward and outward. Coronary, encircling as a vessel or nerve. Cortex, the external gray layer of the brain. Crepitus, crackling sound produced by rubbing together fragments of fractured bone. Cyanotic, pertaining to the blue discoloration of skin from non-oxidation of blood. Debrid, to cut away lacerated or contaminated tissue. Decalcified, freed from lime salts. Diastolic, pertaining to the period of dilation of the heart. Diathermy, heating local tissue by the aid of the high frequency current. Dilated, a vessel or organ which has expanded. Disseminated means scattered. Distal, away from the center of the body. Ecchymosis, discoloration due to an effusion of blood into surrounding tissues after a rupture of the vessels. Embolus, any foreign or abnormal particle circulating in the blood as a bubble of air or a blood clot. Epiphysis, a part or process of a bone which ossifies separately and subsequently becomes a part of the larger bone. Epiphyseal, pertaining to an epiphysis. Epithelium, the covering of the skin and mucous membranes, consisting wholly of cells of varying forms and arrangements.
That's it? Wow, that went by so fast. I guess the faster you go, the faster it seems like the videos are going too.
Hello, welcome to the literary and jury charge portion of the 120 class. We're going to start out with an article, some literary on the human heart. I'm going to read this once at 100 and again at 120.
Okay.
So we'll start off at 100. Ready? Here we go. The human heart is the most important organ in the body. It is a muscular organ, averaging 10 ounces in weight. The heart has two sides. The right side pumps the blood through an artery to the lungs, where it deposits waste such as carbon dioxide and picks up oxygen. It then travels to the left side of the heart, where it is pumped out to the arteries, giving fuel to the body. On the return trip to the heart, the blood travels through the veins back to the right side of the heart, where it begins its process again. A young child's heart will beat at almost twice the rate of an adult's. Physical activity will cause the heart to beat more rapidly, whereas sleep will produce a slower heartbeat. Okay, so I will read that again, and I will pick it up this time to 120. Ready? The human heart is the most important organ in the body. It is a muscular organ, averaging 10 ounces in weight. The heart has two sides. The right side pumps the blood through an artery to the lungs, where it deposits waste such as carbon dioxide and picks up oxygen. It then travels to the left side of the heart, where it is pumped out to the arteries, giving fuel to the body. On the return trip to the heart, the blood travels through the veins back to the right side of the heart, where it begins its process again. A young child's heart will beat at almost twice the rate of an adult's. Physical activity will cause the heart to beat more rapidly, whereas sleep will produce a slower heartbeat. Okay. I have some jury charge for you.
Jury charge.
A basic issue to be determined by you in this case is whether the plaintiff, Sergeant Harris, was a guest of the defendant, Sergeant Wilson, at the time of the accident in question. This is a basic issue because the liability of the defendant differs depending on whether the plaintiff rider was a guest or a passenger of the driver of the vehicle involved in this accident. Although a person may be both a guest and a passenger, according to the law, the two words differ in meaning. A guest is one who is invited to enjoy the hospitality of the driver of a vehicle, accepts the ride for his own pleasure without conferring any benefit or compensation upon the driver, where, however, the driver receives compensation. This need not be money for the rider's transportation, and this compensation is understood by both to be given and received for said ride. The rider is a passenger, not a guest. So I read that at 100. I'm going to read that again at 120. Ready? A basic issue to be determined by you in this case is whether the plaintiff, Sergeant Harris, was a guest of the defendant, Sergeant Wilson.
You know what? I'm looking up Sergeant. Hold up. How do I spell Sergeant? Sergeant. Am I not writing it like that?
At the time of the accident in question. This is a basic issue because the liability of the defendant differs depending on whether the plaintiff rider was a guest or a passenger of the driver of the vehicle involved in this accident. Although a person may be both a guest and a passenger, according to the law, the two words differ in meaning. A guest is one who is invited to enjoy the hospitality of the driver of a vehicle, accepts the ride for his own pleasure without conferring any benefit or compensation upon the driver. Where, however, the driver receives compensation, this need not be money for the rider's transportation, and this compensation is understood by both to be given and received for said ride. The rider is a passenger, not a guest. Okay, I have an article here. And This is called identity theft, a new kind of larceny. Ready? In 2005, Choice Point, a personal information clearinghouse with huge stores of private data on millions of Americans, announced that it had been the victim of a fraud perpetrated by thieves posing as legitimate business customers. The firm quickly notified more than 145,000 people nationwide that critical personal information, including credit scores, social security numbers, street addresses, and more, had been stolen in what looked like a massive identity theft scheme. Later that year, more than 100,000 Bank of America customers were notified that their financial records might have been stolen. MasterCard reported that 40 million credit card accounts had been compromised by a security breach at a payment processing center. Identity theft, which involves obtaining credit, merchandise, or services by fraudulent personal representation, is a special kind of larceny. According to a recent Federal Trade Commission survey, identity theft directly impacts as many as 10 million victims annually, although most do not report the crime. Identity theft became a federal crime in 1998 with the passage of the Identity Theft and Assumption Deterrence Act. The law makes it a crime whenever anyone knowingly transfers or uses without lawful authority a means of identification of another person with the intent to commit or to aid or abet any unlawful activity that constitutes a violation of federal law or that constitutes a felony under any applicable state or local law. The 2014 Identity Theft Penalty Enforcement Act added 2 years to federal prison sentences for criminals convicted of using stolen credit card numbers and other personal data to commit crimes. It also prescribed prison sentences for those who use identity theft to commit other crimes, including terrorism, and it increased penalties for defendants who exceed or abuse the authority of their position in unlawfully obtaining or misusing means of personal identification. Anyone can fall prey to identity theft, even celebrities. In the year 2000, for example, golfer Tiger Woods learned that his identity had been stolen and that credit cards taken out in his name had been used to steal $17,000 worth of merchandise, including a 70-inch TV, stereos, and a used luxury car. In 2001, the thief, 30-year-old Anthony Lamar Taylor, who looks nothing like Woods, was convicted of falsely obtaining a driver's license using the name of Eldrick T. Woods, Tiger's given name, Woods' social security number, and his birth date. Because Taylor already had 20 previous convictions
20
of all kinds on his record, he was sentenced to 200 years in prison under California's 3 strikes law. Like Woods, most victims of identity theft do not even know that their identities have been stolen until they receive bills for merchandise they haven't purchased. According to the National White Collar Crime Center, identity thieves use several common techniques Some engage in dumpster diving, going through trash bags, cans, or dumpsters to get copies of checks, credit card and bank statements, credit card applications, or other records that typically bear identifying information. Others use a technique called shoulder surfing. It involves simply looking over the victim's shoulder as he or she enters personal information into a computer or on a written form. Eavesdropping is another simple yet effective technique that identify thieves often use. Eavesdropping can occur when the victim is using an ATM machine, giving credit card or other personal information over the phone, or dialing the number for their telephone calling card. Criminals can also obtain personal identifying information from potential victims through the internet. Some internet users, for example, rely to spam unsolicited email that promises them all sorts of attractive benefits while using or requesting identifying data such as checking account or credit card numbers and expiration dates, along with the victim's name and address. Identity theft perpetrated through the use of high technology depends on the fact that a person's legal and economic identity in contemporary society is largely virtual and supported by technology. Interesting.
Oh my god. That went on for so long. No, it didn't. Not that long.
We have
I did not keep up at all.
some literary, and this is called taxation. Okay, here we go. Saving on taxes involves the detailed task of record keeping. An essential element of complete tax planning is to establish a good record-keeping system. Your detailed records will help you to compute your income and deductions at the end of the year and to plan for the future. With receipts accumulating during the year, there is a tendency to overlook certain items. You must have a record to present to the IRS if your return is audited. The establishment of a comprehensive record-keeping system will ensure completeness and accuracy and will also eliminate many problems at tax time. After you have collected your monthly checking account statements, segregate all the tax-related receipts, keeping 1 year's receipts separate from another. If your occupation involves travel, meals, or entertainment of clients, you should keep a daily computer log or journal of these expenses. If you own your own home or have other investments, such as stocks and bonds, plan your investment strategies in order to minimize gains at tax time. If you use your home as your office, you may take deductions for business-related expenses. The retention of past tax returns is important in the event you are audited. Previous tax returns may be necessary if you plan to income average. All interest and dividend statements should be retained in case you are audited. Tax records should be kept for a minimum of 3 years. The IRS may go back as far as 3 years To question A, return. Okay.
4 more minutes. And then we move on to Q&A.
Going to give you some words and then I'm going to read a paragraph to you, and these are all on legal terms, okay? You're going to hear verbatim, voluntarily, executed, transcript, disclosure, affidavit, which you can write that as AFT or AFD. I've seen it both ways. Deposition, DEP, concealment, jurat, clause, interrogatories. So interrogatory is trog, T-R-O-G, docket, and contempt. Okay. All right, here we go. Ready? A voluntary...
Wait a second. Let me look up interrogatory. Trog. It is trog. Okay, it's trog for me too. Trog.
T-R-O-G, docket, and contempt. Okay, all right, here we go. Ready? A voluntarily written statement executed under oath before an official of the court is called an affidavit. A jurat clause appears at the end of the affidavit. Interrogatories are questions answered under oath outside the courtroom. The court reporter prepares a verbatim transcript of most proceedings. The disclosure of facts known about a case is prepared in question and answer format in a deposition. A party is guilty of concealment when the facts known about the case are withheld. This action can lead to a contempt of court charge. The trial date for a case is entered on the court docket. So I'm going to read this now at 1:20.
Keeps doing that.
Ready? A voluntarily written statement executed under oath before an official of the court is called an affidavit. A jurat clause appears at the end of the affidavit. Interrogatories are questions answered under oath outside the courtroom. The court reporter prepares a verbatim transcript of most proceedings. The disclosure of facts known about a case is prepared in question and answer format in a deposition. A party is guilty of concealment when the facts known about the case are withheld. This action can lead to a contempt of court charge. The trial date for a case is entered on the court docket.
Okay, well, I didn't do it that good.
Okay.
I missed a lot of sentences.
I've got some literary. Actually, we only have about less than a minute. So I'm going to just read to you one last little paragraph that we had more time. All right, here we go. This is just a small phrase review, okay? Here we go. Did you ever ask Mr. Brewer how many students he has in his 9 o'clock class? He may have overlooked the fact that he has only 35 computers in the computer room. Before the final class assignments are made, verify the class count. This way, when the final rosters are printed, we can eliminate a good many of the changes. And that was at 1:20. Okay, that concludes our literary.
Time for Q&A. This is gonna suck. I can barely do the jury charge in literary. Q&A is going to be so difficult. Okay.
Hello, this is the 120 Q&A practice.
Yes.
We're going to start off with the plaintiff questioning. Here we go. Ready? So you paid $300 or $400 in cash for them? That's right. Where did you get the $300 or $400 cash you used? I made it gambling at the casino. I was in the business, the game of chance. Sometimes I made money, sometimes I didn't. Did you deposit the money you made gambling in a checking account? Sometimes I did, yes. So did you then write yourself a check for $400 immediately prior to the swap meet for the purchase of these sound systems? I don't think I did. I think I already had that money in cash, and no, it was in my savings account. So you took it out of your savings account? I think so, yes. Where is your savings account located? The First City Bank in downtown Detroit. So that savings account will show a withdrawal of $400? I am pretty sure. Is that where you got the money that you took to the swap meet to purchase the stereos? That's correct. How many stereos did you buy at the swap meet? I told you 3 or 4. How many? 3 or 4? 3 or 4. Did you withdraw $300 or $400? It could have been $300 or $400. Either 3 or 4. I am not exactly sure. So it would be either 3 or 4. How much money did you withdraw out of your savings account before you went to that swap meet? I don't know. I really don't know. Did you do it for the purpose of buying stereos at the swap meet? I think I took some out for spending because I needed some money and some of the stereos. Did you frequently visit swap meets held throughout the state of Michigan? Yes, I did. How often had you visited the Lansing State Fairgrounds swap meet? I don't remember. Several times. How often had you purchased stereos from this particular individual, Eddie Trent? I don't remember. 2 or 3 times. When you purchased these stereos, didn't you wonder how he could afford to sell these items at such a low price, at below wholesale prices? No, I just knew it was a great deal. I knew I could make some money. Did you ever think that this merchandise that you were purchasing might be stolen property? No, I just thought it was a good deal. You said you visited this swap meet several times. How many times? Oh, about 3 or 4 times. In all the time you visited the Lansing State Fairgrounds swap meet, how many stereos did you purchase from Mr. Trent? Oh, between 8 and 10, not more than a dozen. Can you give us an exact number? I think 10. Okay, we'll switch transcripts.
Jesus Christ.
This is going to start out with defense attorney. Here we go. Now, Mr. Tyrell, you have stated that when you first saw Diana, She appeared to be a normal, level-headed young lady. That's correct. Did you ever see Diana when she was under the influence of some kind of drug? No, I did not see. Did you ever see Diana when she appeared to be drunk or under the influence of alcohol? No. Did you ever hear that Diana had some kind of a drug problem? I had heard some rumors that she could have been a user. I probably heard it from my sister Karen. We sometimes discuss family problems, and it may have come up. We knew that something was wrong. We didn't know what indicators to look for, but we knew something was amiss. You keep referring to your sister Karen. Is that Diana's mother? Yes, that is correct. That is your sister or half-sister? My half-sister. That is Diana's mother? Yes, it is. Were you ever told that Diana was heavily into all kinds of drugs? No, never. That Diana had experimented with marijuana? No, never. That Diana had tried PCP and cocaine? No. That Diana used LSD? No, nothing. Your Honor, I have nothing further at this time. Redirect, Miss Delaney. In conversations with Mrs. Bishop, the school psychiatrist, psychologist, did she ever tell you that she suspected Diana was into crack? Was she aware of anything? Your Honor, I will object to the last part of the question. The last part of the question is objectionable. All right. Did she ever tell you that Diana was into drugs? Not really. She insinuated that Diana's grades were slipping because of her involvement with a bad crowd at school. We both knew something was wrong. Nothing definite ever came out. This was a difficult situation regarding a drug problem, a serious drug problem. Well, did you ask Karen if Diana was ever involved in drugs or alcohol to any extent? Do you know what I mean? No, I didn't go into her personal history. We hadn't seen each other in 10 years, and I wanted to keep a good relationship with her. We both knew there was something wrong with Diana, but we couldn't really communicate openly without embarrassment. And you weren't able to talk about it? Did it appear that Karen's husband, Brad Stewart, knew anything about the drugs at that time? He didn't say anything. Karen and Brad were having their problems too. All right. In talking to Karen, did she mention anything in the nature of alcohol or narcotics as far as Diana was concerned when Diana had the automobile accidents? There were many problems that arose out of the car accidents. Because of the frequency of them, no one would insure Diana. She lost her driver's license, and Karen and Brad refused to let her drive their car. Did you ask Karen and Brad to take Diana to a drug rehabilitation program in New York City? Well, I said, why not consider putting Diana in a drug rehabilitation program? Her problems are affecting the whole family. But Brad and Karen hadn't accepted the fact that she really had any problems. Did you talk to Diana personally, or just to Brad and Karen? No, it was their child, and I felt that since it was their child, it was their problem situation to cope with. How long have you known your half-sister, Karen? I have known her since she moved up here. I think she called me about a week after she moved to Albany, and that's when I met her. I hadn't seen her in 10 years, but we never really knew each other as kids anyway. Okay, and when you met her, I take it you also met Diana? That's correct. And how long have you known Diana? 2 years, since April of 2012. And have you had occasion to see Diana once in a while? Oh yes, we go over to Brad and Sharon's house a lot. We have dinner. We go on picnics. Diana and her brother, Ted, helped me move into my new apartment. How did Diana strike you the first time you next saw her? She was shy at first, but very cooperative. She was always friendly to me. She always spoke to me and seemed like she needed a friend. I guess she and her father fought a lot. You said Diana helped you move? Yes, she did. Was this over the objections of Diana's father, your brother-in-law? I don't really know. No further questions. Did you ever see Brad with his children? Yes, many times. What was his attitude toward his children? Oh, he was a good father. He was affectionate. He always was throwing his arms around her, teasing her. Have you seen Brad since he has been in jail? No, yes. On one occasion I came to court and saw him here. Thank you, Mr. Tyrell. No further questions at this time. Mrs. Delaney, any other questions? No, Your Honor. Okay, that concludes our Q&A practice for the 120.
Damn! It was one transcript. One transcript. Hungry. I think I won't do the 120 class next time just because it takes so long to get through all of them together.
Hello, this is a Q&A test for the 120 class. Plaintiff attorney is Mr. Cox, C-O-X. Defense attorney is Mr. West, W-E-S-T. Again, plaintiff attorney, Mr. Cox, C-O-X. Defense attorney, Mr. West, W-E-S-T. This is going to start out with the court.
The court, okay.
Ready? That will be fine. Mr. West, before you proceed, let's take a short break. We will be back on the record in 15 minutes. Let's go back to the paper for a few minutes. Do you remember if anything was printed on the top of the paper? I think it had Irvine Police Department on it. Okay. Now that I remember, it did. It looked official. Now, you were saying that Amanda tried to write something. Are you saying you saw her make marks on the paper? I saw her writing some words, yes. Was it on that official piece of paper that the officer gave her? Yes. Okay. About how many words did she write on the paper? Was it one word or one line, or just how many would you say? I really can't remember. Well, was she writing on the paper? Yes, she was. Okay, was it a lot or a little? You know, was it a piece of paper with one or two words? Was it some paper with 3, 4, 5 lines on it? Was it one of those choices? There was not much writing on it, as I recall. Well, more than one line? I don't remember. I really don't remember right now. I'm sorry. Okay, perhaps you can remember how long she sat there and held that pencil and tried to write. Can you? Was it 1 minute, 5 minutes, or 10 minutes? Do you remember how much time it was? I don't remember. Well, was it a very short time? I don't remember. Could it have been half an hour? No, I don't believe so. Perhaps I can help you, counsel. Let's think for a few minutes about what was happening at that time. Okay, I'm thinking. Now, was it approximately 15 minutes that she was writing on the paper? Yes, I think that would be about right. All right, counsel, let's leave it at that. Okay, Your Honor, I have nothing further at this time. Mr. Cox, do you have any further questions? Yes, sir. Go ahead. Now, who was in the room while she was sitting there trying to write? What do you mean? Well, was it just you and Amanda? Oh, I see what you mean. Yes, it was just the two of us. Was there an officer in the room? Well, there was an officer there. It was a booth with an open space in it, and the officer was sitting at the desk. It would be almost like he was there, at least. I guess that's what you would call it. Well, there was a partial partition between us. As you sat there with Amanda, and she was trying to write, could you see over the partition and see the officer? In other words, did the partition block your view? No, it did not block my view. I could see the officer. How high was the partition? Almost as high as this witness stand. Was there anything on it? In other words, was there a ledge on it? I don't know what you mean. The officer was in front of you and not to the side of the partition. Is that right? The desk area is a very large area. How many officers could you see as you sat there with Amanda when she was trying to write? There was one officer there at that time. We have reached the time for our break for lunch. The jury is admonished that you should not discuss this case amongst yourselves. Everyone please be here promptly at 1 o'clock.
That's it? That's it. Okay. Sorry, I had to pause for the train. Okay. Yeah, doing 120 words per minute alongside 80 and 100, it seemed like a good idea at the time. But as I'm sitting here with my hands very, very fatigued, I don't think it's productive. So next time I'm just gonna do the 80 and 100 words per minute classes. I'll leave 120 for when I'm done with 100. I still have a ton of videos for 100. No, I don't. Not a ton. I'm at 161. That's the video that I'm on. 161 out of 195. That's a lot. It's a lot less than I thought it was. For the 80 words per minute, there are 250 videos, and I'm at the 51st video. For 120, there are 200 videos. It's a lot. All very beneficial. Okay. Now let me see. Who am I gonna raid? How about Akiko? She's playing the new Pokemon game. Okay, I'll be back tomorrow to play Yakuza Kiwami 2. That's it for this stream. Goodbye, everyone.